Good morning and welcome to the Otago Regional Council hearing on the policy on dangerous dams, earthquake-prone dams and flood-prone dams. I'm chair of the hearing today. My name is Councillor Kate Wilson. To my right is Councillor Elliot Weir. We're both hearing the submissions or the oral submissions which add to the submissions that have already been filed. To my left is Caitlin Hazlett, who will be looking after us today, and Rebecca Jackson, thank you, who is the report writer and his the team leader for consents. Now, the process today is that we don't have to do any of the operational health and safety things. The first thing is Rebecca will talk to your report that you've done. You've read the submissions and you've made a report to us with some recommendations, just checking if there are any other matters that you wish to address.
No, not at this stage.
You need to push the red button in order for that to work.
I don't have a red button.
The left one, so right one, sorry, right one.
No, not at this stage.
Thank you. Do you have any questions as we start off? Since we've got the first submitter here, we'll start with the first submitter, but I'll ask some questions later about other hearings, recognising that this is a process which all councils are trying to align their with a template policy. Welcome, Peter. I think you're joining us, hopefully visually. And kia ora, Peter. You're muted. We need you unmuted.
Can you hear me okay now?
We can. If space, we might need to increase the volume slightly.
Okay. Just excuse me.
Oh, that's all good now. It sounds better.
Okay. Cheers.
What is the dam behind you?
That's oh, I've just lost the hearing. Here we go. Where am I? That's the Lake Pukaki spillway. And it was a job we worked on in terms of some repairs on the Lake Pukaki spillway up near Twizel there. Yeah. And it was a picture taken very early in the morning by one of the guys I worked with there. Yeah, it's quite stunning, really.
Beautiful. Now, Peter, I'm just checking in who you're representing today. I think you're representing a number of submitters.
Yeah, that's correct. The Last Chance Irrigation Company and the Falls Dam Company.
Great. Now, we've all read your submissions.
Okay.
We've both read your submissions. And feel free to take us through any points that you want to clarify and then take some questions, if that's okay.
Yeah, sure. Are you comfortable that you've got enough knowledge about both the companies and their assets in terms of Last Chance and Falls Dam? Obviously, Falls Dam.
I certainly understand Falls Dam better than I do Last Chance. So, but tell us the information that you think may be helpful, and you've got plenty of time.
Yes, I see that. Yeah, well, it won't take much time. No, well, Last Chance is a community-owned irrigation scheme, and in terms of dams, it has two thin arch dams that were built back in 1935, being Butcher's Dam, which is the one as you're heading into Alexandria, you see the reservoir associated with that, and Conroy's is down one of the back roads towards Clyde. So I can show you a map of the location if you wish, but that's basically where we're at the moment. And the second one, you're aware of where Falls is and its location. Again, that serves about 4 irrigation companies and quite a large area, as you can imagine, and it's pretty topical at the moment.
Can I just check, you've got races as well with those, but none of those would meet? Because
not as far as we know at the moment, yes.
They're not like canals?
No.
Yeah, just checking.
No, there are small races. It would be, yeah, I couldn't say definitively whether they're all in that category, but it'll be part of the process of as we work through these dam safety regulations to actually isolate some of those areas. And I think that's not unusual for falls or our Last Chance definitely won't have one, but falls may, but I doubt if they have. But there's a few things to work through in terms of regulations through the whole of Otago in terms of classifiable structures.
Thank you.
My background is a civil engineer. I've been involved with the dam safety legislation and associated regulations and the false starts since about early 2000s. So I've had a little bit of familiarity with the process and where the dangerous and flood-prone dam, dangerous and earthquake-prone and flood-prone dam policy or situation comes from. I suppose our 2 points in terms of both submissions are that, and it may be a function of our interpretation of the wording, there's a statement there saying the state of all dangerous earthquake-prone and flood-prone dams as defined in the Act and the regulations must be known. I'm not sure whether we're interpreting that correctly in terms of this current state of knowledge or a future state of knowledge. So what we're saying is, well, look, yeah, many of the structures, especially by the larger generators, there is a significant knowledge around, you know, the state in which their dams are in terms of all aspects, in terms of earthquake, flood capacity, etc. For some of the smaller schemes, that's not the case. And I think what we're saying is that as part of the regulatory process that we're going into, that will become the state, but that state of knowledge will improve significantly. But at the moment, it's in some cases it's not there. So to assume that it is there, I think is ambitious. And I think there's other aspects to it too. I think even the number of classifiable dams in Otago, well, especially in New Zealand, is a little bit unknown. I'm not sure the exact situation in Otago, but I am reasonably sure there's still some structures out there that in a classifiable will have to be classified that are unknown. Right, so the state of the whole dam inventory in the Otago, I would sort of postulate that it is, you know, it's not, the knowledge isn't quite there yet, but it will come. The second thing is that the dangerous and flood-prone and earthquake-prone policies are based around, in the regulations, there's a reference to ASNZ 1170, number 5, and that is under a bit of revision at the moment. It hasn't been committed, but because basically a whole new seismic hazard model has actually been produced by GNS in New Zealand, and the whole building industry is trying to manage their way through that, given the likely loadings that are going to come out in terms of return period, etc. So there's a little bit of lack of knowledge there. There's a revision coming up there. It does affect this policy, although in theory it doesn't affect dams. It is stated in the regulations that we should refer to it. So all I'm saying is the state of knowledge is such that the council shouldn't assume that everything's known at this stage, because in my opinion, it's not. The second part of our submission was really around the wording, and I suppose the 2011 version had slightly softer wording in terms of how the council would sort of work with the community and the owners to work through issues that if they did arise, as opposed to coming in with blunt instruments and a regulatory hat on to, you know, sort of, cause a bit of angst. So that, I'm sorry, my wording isn't great, but we are concerned that, you know, that council takes an attitude, or at least follows through on the policy with the community, because some of these assets are very important and some are heritage, and they, there's a bit of work to be done there, and these things, and even the aspects of defining the probability of failure in some of these instances where you're analysing it, there is a range, not necessarily a discrete answer. And that has to be worked through. And bearing in mind that many of the structures are not like buildings that they are left after they're built. They've usually got dam safety assurance programs around them. They're inspected on a regular basis. They get an annual inspection. And there are other ways the risk is being managed in the interim. So that's basically our submission, and open to any questions, really. Thank you.
Thank you. Do you have any questions? Okay. Peter, thank you very much. And I'm really good to have someone of your knowledge addressing us and giving us the opportunity to think about this more broadly. I'm interested about the risk. What this is trying to do is to mitigate the risk should a failure happen with the dam more or less full, really, or a high quantity of water. And I just want to test, maybe considering the season we're in, where a lot of these dams are actually quite dry, and that's often when you get the issues happening. I think when the sides dry out and or they can be assessed. I may have that wrong. I'm just considering. Yeah, and I'm mainly focusing on being so dry at the moment. So Falls Dam, it's very dry at the moment. Is it a earth dam or it's a what sort of dam?
It's a concrete face rockfill structure.
So
yeah.
that doesn't have an issue, doesn't.
Yeah, they're unlikely to have issues. Well, the hazard created by the impoundment obviously is a lot less when it's as low as it is at Falls at the moment. I think you have no problem at all even if you had problems through the structure. And Conroy's is the same, and Butchers, you'll probably note, is well down at the moment, and they do vary at certain times of the season. So to give you an example, Falls, while it's old and it's got some, it's like older structures. It has suffered a bit of not damage but deterioration over the years. It's a concrete face rockfill structure. History suggests, and in terms of any failures around these structures, is unless they're overtopped and sort of scared away, that earthquake effects, etc., it's reliant on the impermeable nature of the concrete lining on the upstream face. And in general, they have been known to, in those situations where they've had an incident, they leak a lot more, but they don't necessarily fail in a catastrophic manner. I mean, I have to caution my statement there in the fact, if you get an extraordinary event that happens in the wrong place at the wrong time, possibly. But as I say, that's been the main failure mode around these structures. The concrete arches, they can fail quite catastrophically, but the history of failure in these structures throughout the world there's not a large number of failures, but at the same time, I think it's recognised throughout Otago that some of these structures don't meet modern day standards, but it's just how to analyse them and get sufficient knowledge around them to actually establish what the next step is. And there are various remedies. Either you could obviously strengthen it, alternatively, dewater the reservoir, basically stick a hole in it and take away the hazard. I mean, there are several remedies, but at the same time, some of the impacts on the community might be quite severe.
Thank you. Just so we've got three reasons we're doing this. One is earthquakes, one is flood prone, and one is depending on the risks, whether they become dangerous. They can be dangerous just by their nature, I presume. One is
to give you a background context. In the dam engineering world, there's no such thing as the terms dangerous, flood prone, and earthquake prone. This was a this was a byproduct of the new 2004 Act,
Mhm.
where there was a cut and paste from the Building Act into to manage dams, right? So
Yeah.
we went through a process of trying to manage how we could apply logical thresholds, and we could only go back to the risk. You're aware of the third standard for buildings being if they're earthquake prone, if they're under 33% of the National Building Standard in terms of their structure. Well, we related that risk back into dams, or there's some civil papers on it. And that's how we sort of determined, these thresholds that sit in the regulations now in terms of the loadings. Now, the dangerous category came out of buildings again,
Yes.
and it comes from the wording called in the likely, I can't remember the exact wording, but it's not an actual figure. It's like 1 in 50 year return period. It's actually just a series of words in the ordinary course of events, I think the term was, and excuse me if I've got it wrong. And that came out of, and the interpretation of what that meant came out of a decision on the Mataha debris slides in the North Island. And there was a definition that came out of that ruling. And that's the only one I can go back to find any definition of a return period in the ordinary course of events, which was basically 1 in 50 year return period. That's where the threshold came from. So it's a bit, yeah.
And look, and that's all very, very helpful just to understand. And thank you for your main 2 submission points. I'm just can I just use your time? When Joe Boggs comes along to you as an engineer, they've got a dam, the policy suggests it's their role to assess it and then for an engineer to audit it, I think. Is that correct? But they'll get an engineer to do both, that's I'm sure.
Yeah, there is, this is back to the regulations. There's we have just revised the New Zealand Dam Safety Guidelines around potential impact classification, and that's the assessment. Now, in the regs, they have there is an ability for the owner to go and do a potential impact classification on the structure. Now, and get it signed off by a recognised engineer. There is a bit of concern amongst the engineering fraternity that sort of assessment is done properly. So there is a sort of a push towards, especially with the more larger structures, the ones that may have a potential impact, may have potential impact downstream, to have a more structured and probably professional view or assessment on that rather than just the owner. And but there are obvious cases where there's a small pond that may be classifiable, may or may not be classifiable. You determine that, and then there may not be any impact downstream, and it could be quite easy for an owner to go and go through a list of criteria and say, well, look, I haven't got anybody downstream. It goes into a small river, and it doesn't cause anybody a problem. So therefore, I'm going to classify it as low PIC and get a recognised engineer to come along, and they might look at it in a fairly pragmatic view and say, yes, no, you seem to be in the right, in the right ballpark. I'm happy to sign it off. So, but there is a bit of a problem around, I suppose, people classifying these structures, especially larger structures, without the requisite professional qualifications. We have concerns about it.
There's certainly, and I don't know what size it would be, but while we can't necessarily have a policy that goes against the regulations, or maybe it narrows it down from court, but it we could have a footnote that suggested it at a certain size that it should be possibly done both, yeah. It's a hard one because the regulations do actually provide for the owner to do that job, doesn't it?
It does, yeah. I mean, we've got the Tasakaka Butchers Dam, which is quite a significant structure in terms of holds a fair bit of water, but it's got no population downstream. It goes into the lake at Roxburgh, and the impact of failure is pretty much minimal. The only thing we've got downstream is probably the bike trail. But they're sort of an itinerant population, which a fairly narrow area and sector, and so there are examples.
It's also people sleeping in a bed. Can I just it raises another issue. One of these submissions talks about notifying TAs, but the other way round it occurred to me is dam owners being advised of consents for houses downstream, because today you could be a low impact dam, tomorrow a subdivision of 50 houses below you changes your status, and you wouldn't necessarily be notified unless there is that process. Has that been thought about or been discussion at that level?
Yes, it has, but it's I couldn't say it's been solved. There are obviously, I think it's sort of a little bit of an onus on the owner to be aware of what's happening downstream of them, and and even then, to sort of go and object to somebody building downstream because you've got a structure upstream. I'm not quite sure how that stands at the moment. I'm sorry, I'm not a very good answer, but that's about as good I can give.
Have you any questions now, Councillor Ware?
Yeah, I was just hoping to drill a bit further into one of the points you were discussing around the potential information gaps, and the sort of, you touched upon the information needing to be known in the policy, and that not necessarily all the information will be available to the asset owner. And I'm just wondering what the fear was that would what the consequences would be for the asset owner in that circumstance, like where the conflict in the policy is. Sorry, I've explained that terribly.
Yeah. I do. That's why I'm sort of just a little bit cautious on the wording, and that's why we were keen to see it, have another look at it, maybe. I think you've got a regulatory framework now. Hopefully that gets ticked off by the 13th of May, or any changes that may occur fairly quickly. But I think it's in train to actually come through. So there is a process there where they've got 3 months at this stage to do a potential impact classification if they feel they've got a classifiable dam, and they've got to get it signed off by a recognised engineer. Again, the actual implementing that is going to be challenging. And they've got 2 years. I'm probably not repeating the regulations too well, but they've got a couple of years to actually form a dam safety assurance program, and around that, I think they still have to every 12 months provide a certificate around the state of the dam and the dam safety assurance program, etc. And I'm not sure that the exact timing of that, but in terms of when that comes into effect, but it has a significant impact in the fact of raising the bar and the awareness of companies, etc., around that, because, and one of the aspects of that certificate is designed by the chief executive. It's actually signed by the chief executive of the body corporate, which has a fairly significant implication on all dam owners to actually make sure they're doing what is deemed to be, prudent, and that even boards of directors. So, I think there's going to be obviously a complete, a significant raising of the awareness, and also from a regulatory or governance point of view, a significant sort of, it's going to definitely put it in the headlights in terms of owners. Now, all I can say, I think that's in managing the risks around this is going to be of a benefit. But in terms of having, I think that'll drive the need to get more information on these structures and see where they stand in terms of aspects such as flood prone and earthquake prone. And I think that's what will drive the information, or to fill the information gaps. But it's happening at the moment. It's probably in certain areas it's happening quicker than others. I hope that's answering your question.
Yeah, just to clarify, so you don't necessarily think that is a burden that's too onerous on the asset owner to fill those information gaps, just that it needs to be recognised that there may be those information gaps, or do you think that burden to get that information would be too high?
I'm not sure I'm answering your question, but I think all we just wanted is a recognition that owners should strive to be aware, or wrong wording, but strive to be aware of the state of their assets. I mean, in terms of managing the overall risk.
Cool. Thanks.
Yeah. Does that sound what you're after?
Yeah.
Thank you. Just because you're here, Peter, and we've got time to fill in, so I'm going to ask you 2 more questions. They are relevant.
Is the press there?
No, I don't think we don't know if they're online or not. No, they're not online. I'm just wondering, this the cost both of doing the initial. I mean, if you were in, if we've got a lot of people commenting about the cost and submissions and concerned that it's quite onerous, and we've got very limited stuff that we can do about it. But just understanding that for the purposes is so. One part is the cost. So you do the first, if you're employed, the actual classification and then the audit of a normal farm, modern and put in storage dam, what that cost might entail on a first up and annual report basis, or whatever report basis it is. And the other one is the capacity, because that has also been suggested as a real restraint, which goes to your point about our ability to be softly potentially at the start.
Yeah, I think the problem. I mean, ideally, yes, there is a. I think off the record, there seems to be resource issues. There's no doubt about that. And then, but that was I think an element of that was the liability aspects around those, being a recognised injury and stuff like that. And they're working through that. I think what we submitted in terms of some of the latest talking talking about the regulations and maybe some softening, etc. We said, well, look, why not push out the timeframes? But the problem is that timeframes are in the Act; they're not actually in the regs, and that's what's caused the. It's easy enough to change the regs to push out your lead times to get this information in. But the issue was it wasn't actually in the regs, it was in the Act, and it was a hell of a lot harder to change the Act than it is to change the regs. So that was one of the bigger problems. And I think the only degree of, I suppose, leniency or can come from almost a council point of view to say, well, look, as long as they're working towards it, these guys, if they don't meet a 3-month threshold, is it and when you're managing the risk, is it that bad? the other aspect in terms of cost was we need a lot more recognised engineers. I think that's pretty clear. Once we get over that thing, I think you'll get a bit of competitive tension around those costs, and there has been moves, I think, to sort of cartel some of the work in terms of through Irrigation New Zealand, etc., the picking on one or two providers to say, well, look, what can you? We've got a series of people that need the work done. Give us a competitive price, and there has been some efforts around that. I don't, like I can pretty, from my point of view, we weren't there to gouge the industry. Our original intent was not to gouge the industry. It was beyond, or the dam industry. It was in terms of costs. But at the same time, the chances of a failure with an unregulated system was a hell of a lot higher than it was with a regulated system. So it's sort of, well, that was the opinion, So I haven't really answered your question unless you got something specific. What will the cost be? I think there are some remedies there. I think time, if people can be allowed time, if a competitive market can be set up, enough people doing the job, I think that will help.
Because you're doing Falls Dam, and that's probably a more complex one. So if I took I presume under your system, you'd have to do both Butchers Dam and Conway Dam together because that one feeds into the other.
No.
Okay, they're different.
No, they don't. No, okay. They're totally different catchments.
Okay, sorry. I thought it was the connection between them. That's fine. So take one of those dams, say Conway because it's the smallest, I think. I don't know by volume.
That's right. Yep.
Yep. So how much would you expect the initial assessment to cost if you use an engineer, and then the auditing in dollar terms, or would you?
I couldn't possibly comment, but having a really close knowledge of this, but yeah, we've had some work done at the moment, and we're talking for Conroy's dam break assessment plus a potential impact classification assessment in the order of $13,000.
13
to $15,000.
And then you have to have it audited after that?
That's right.
And the audit would be more a desktop exercise?
Yeah, I mean, I just, I can't really, I don't know how much the audits are cost. We haven't tried that one yet. I think the work we've done is pretty professional. It's done by a reputable entity, and it's certainly I would as a recognised engineer, I don't think I'd have any trouble signing it off.
Yeah, and so
I would imagine that depending on liability and stuff like that. I got to be careful here, but I don't. There were figures quoted at the last symposium we had of sort of 5 to 10, but I don't think they'd hit that. I mean, it is really an audit role, and it's just and as long as you've got the ducks in a row in the right places, the only problem, and this is a wee bit off the record, but the only problem I see is where the farmer, if he's got a structure that and he does his own PIC classification, and it's not quite, and it sits on the edge, then the recognised engineer almost becomes the first person on the rack, off the rack that actually has got a professional background, so that he signs it off. So he's reliant on not that I'm saying they wouldn't do a job, somebody with not quite that professional background, he's relying on them to have done the job they're supposed to. So there is a debate whether he's the recognised engineer in that case starts becoming a peer reviewer.
Yeah.
It's where the liability sort of, sorry, this might be a personal opinion too, just be careful.
No, the insurance premiums, I'm sure, go up substantially in that case. liability. That's really, really helpful, understanding those costs. How, and I'm sorry, I haven't gone into the detail because it's not important so much, but how often do you, if you're a low PIC, how often do you have to get that done?
Every 5 years.
And if it's a high PIC?
It's the same.
It is the same.
Yeah,
Sorry.
I think it's the same. I think it's the same for all.
Okay, it doesn't change.
Yeah, it doesn't change. Yeah, it's basically based on that downstream population changing or something like that. That's the worry.
Thank you very, very much for your time. I have no more questions. Sorry, Rachel, do you have any questions?
No, I'm good, thank you.
Just one other thing, in terms of those costs, I think Gavin Palmer was at that symposium. You may want to talk to him as well.
Okay, well, I'm scared to ask what you think a large dam, perhaps Falls Dam or one of those other ones might cost.
Oh, well, we've had the work done on them too, but I mean, they're not orders of magnitude different. They're just, it's around the analysis and in terms of dam break assessment. Obviously, the modern models give you a depth and velocity at particular points, and where the guidelines has changed is that we're looking at a depth velocity ratio is in terms of the risk to people as opposed to just to depth.
Yeah.
And so the modern models are 2D models, which basically to carry the floodway down and reflect it into where houses are, etc. And that's what drives the PIC classification. So I mean, for Falls, we've had those studies done. So there's a lot of work going on in the background. These companies are building their picture. There's no doubt about that. They're very aware of it.
Yeah, no, that sounds very good. Thank you very much for your time, Peter.
Okay, thank you.
Thank you for us enlightening your knowledge.
Well, yeah, I hope you asked a bit, and if you need anything specific, just come back to me, and I don't mind helping. Okay.
Thank you very much, Peter.
Yes, thank you. Bye.
I do enjoy having submitters because it does bring the whole thing alive, which is fraught to do. And so I think he was very happy to give advice as wide as possible because it does make it slightly more live, the topic.
Yes.
Now, that is that submission, which gives me a lot better idea of things. Could I just, I think if we just spent some time just going through and checking whether we've got any questions on the other submissions, if we could, in order, and then we'll see how we go. I just think it's nice that people know that we have looked at them and checked information. The first one is Northburn Limited. And this is that one where you've got a new dam, and why does it have to meet something when, we all remember the earthquake-prone buildings in the 1976 was meant to be the cut-off date, and nothing after that was going to fail. There is no similar provision in here to limit new dams, is there?
No, there's not.
And so even if we wanted to, we have no statutory ability to. And thank you. Just want to sign that one off. You didn't have any questions about that one?
No.
New Zealand Transport Agency, you have talked in your report about that point. Sorry.
So NZTA said that they were comfortable with the balance struck or whatever. Is that incorporating their proposed change, or is that just?
Sorry, just in case people, are there no people online? Oh, sorry. So I think you've incorporated a change in your report for NZTA, or was it just the Historic Places Trust?
Yeah, I've done check.
Sorry, I have got quite a few blanks here. This is blanked out. I think it's the way I copied it across to my Word, and it's just done something funny.
Yes, this was about incorporating civil defence.
Yeah.
Yeah.
To notify them.
Yes. Yeah, and I've had discussions with civil defence around that, and they think it's very feasible.
Yeah. But just because NZTA got back saying they were comfortable, is that under the assumption that
I haven't actually read that document. I haven't received it, but I assume that's the case.
email?
Yeah.
It's just, yeah,
Okay,
to view the,
do you want to read out what they said? Oh,
yes.
yeah, if you,
This is just an email from NZTA, Helen Dexter on behalf of NZTA. Her colleagues have considered the recommendations in the hearing report provided by Rebecca Jackson, and they're pleased to say that the report author has recognised there is value in notifying lifeline utility providers of dangerous dams, earthquake-prone dams, and flood-prone dams. We note that the report author has indicated on page 8 that the policy cannot direct to action that the New Zealand Transport Agency sought in its submission, being that the proposed, this is in quotes, that the proposed policy be amended to also explicitly include direct notification of lifeline utility providers where their lifeline utilities could be impacted directly or indirectly by the failure of a dangerous dam, earthquake-prone dam, or flood-prone dam, end quote. However, we note that the hearing report author has liaised with the CDEM Lifelines program lead about the feasibility of CDEM notifying lifeline utility operators about these dams, and subsequently has recommended an amendment to section 4.1 of the policy to include the following statement. Quote, Otago Civil Defence and Emergency Management Group will be requested to notify potentially affected lifeline utility providers, end quote. We consider that this recommended amendment addresses the concern raised by our submission. On this basis, NZTA advises they no longer intend to attend the hearing today, but request this email be tabled.
thank you. Sure. That's good, statement and understood, so we're happy with that. And as you said, CDM have responded well to that. Yeah, next one is from Dawn Sangster on my list. And she submitted about farm dams again, Janue, and the definition, at the moment, and understanding, having read other submissions, there is work behind the scenes that may change the definition of classifiable dams potentially.
Yes, potentially is my understanding.
And so if that happened, the problem is whether it's changed in regulation or an act, we would have to change our policy.
In the way it's currently worded, yes.
Yeah, or we could change the definition just to be classifiable dams as defined by regulations, in which case if they changed, the policy would inherently change.
Yes, I think it makes sense to do that.
Any questions on that?
Yeah, no, I think it's logical.
Yeah, so this has been highlighted in the Waikato case yesterday. It doesn't change, and I'm really comfortable that it wouldn't be a significant change to the policy, but it would just give that room to move.
And if the national legislation did change significantly, but
that would be just the definition of classifiable. Yeah. It would save us doing another process. Otherwise, we could be much more, and it could be actually go the other way as well.
It could.
And become more restrictive. So if you, I'd like to note that and base it on this submission that we may consider, and in light of the advice from Simpson Pearson to Waikato Regional Council, I'm sorry I haven't shared that with you, is consider a reduced definition, just refer to the definition in the regulations.
Yes.
But in other respects, we can't change the regulations, and therefore we can't support his submission. Timing. This is one that did my head in. Sorry. This is the timeliness of the timing minute. So just we do this regulation. Sorry, this policy. 13th of May 2024. The regulations come in force.
Yes.
Within 3 months, what happens?
Within 3 months, dam owners are required to provide a PIC to council.
And then Peter Mulvihill talked about another 2 years to do what?
1 second, I just had the table up.
I'm just going to check that we put the process right
Yeah.
here.
So regulations commenced 13th of May 2024. Up to 3 months after the regulation, so a PIC needs to be submitted up to 3 months after regulations commence or the dam is commissioned.
Yeah.
If it is a medium, if it's a low PIC dam, there's nothing else required until the 5-yearly review of the PIC, which is for all dams. If it is, so a DSAP, which is a dam safety assurance program, is required for medium and high PIC dams. It's required for medium up to 2 years after the regional council approves the PIC. And for high PIC dams, it's up to 12 months after.
So 2 years and 12 months, 1 year.
After that,
So.
Yep.
The DSAP is the dam safety,
safety assurance program.
but that's not, is that the audit? No, that's the PIC has to be audited in the 3 months.
Yes, that's my understanding.
Yeah, so the PIC is done, but the PIC plus audit, because that's a 2-step process, essentially, isn't it?
Yes.
And the DSAP comes from the assurance program, how you're going to deal with the risk.
Yes, correct. And that's there's a template for that in the regulations.
Yeah.
And then after that point, there's an intermediate dam safety review only for the medium and high PIC dams, which is 12 months after the DSAP has been approved.
How quickly do you think these approvals are going to happen?
I'm not sure on that. That won't be something my team does, so I couldn't comment on that, sorry.
So it's not just filing admin wise, someone has to actually tick it off.
The wording says approved, so yes, they'd need to have some sort of confirmation back. Yes.
Which seems slightly more than an admin role, I presume. Oh, it's hard to know.
Yeah, I'm not too sure, sorry.
Thank you. Okay, so I've got, put it in, I've got a high PIC, so within 12 months, so at 3 months from May, June, July, so by August I need to have my PIC in, it's high, so within August 2025 I need to have my DSAP in.
Correct.
And then every year after that, or just 1 year?
It is reviewed every 5 years for a high PIC and 10 years for a medium.
Sorry.
There's a really handy table that I can circulate at some point if that would help with all the timeframes.
Yeah.
Yeah,
I suppose that's where I would have expected to be actually in the policy and
yeah, I guess the risk would be if any of these dates change.
and it is yeah.
And it's still a requirement separate to the policy.
Yeah. Okay. Just sorry, yeah. And yeah, those also relate to new dams, which may or may not happen.
Yeah,
Okay.
and then there's more things that they're required to do. So there's a comprehensive dam safety review, an annual compliance certificate, and then the reviews.
So the annual compliance is the one I'm getting confused with compared to, so there is an annual filing or something.
Yes, so an annual compliance certificate for medium and high PIC dams on the anniversary of the regional authority approving the DSAP. I'm not too sure what that contains. Sorry, I haven't had a lot of involvement in the implementation of the regs.
Yeah, and so anything that is filed will normally come with a fee as well.
Potentially, it would depend what the annual plan says.
Sorry, is this for the submission of reports and information? Yeah, so the proposed fees and charges for the LTP includes set fees for the provision of some of the reports under the regulations. So a set fee, I can't recall the exact detail, but there is some fees proposed in the fees and charges schedule.
And but that's only medium and high.
Yes, not required for low. Low only has to submit the PIC and then review that every 5 years.
So onerous thing if someone does build below you. Potentially,
Yes.
it could change your cost structure and your PIC very greatly.
Yes.
How many houses would it take to change a PIC?
I do not know if there's a set number.
No.
No, I think it would be up to an engineer to determine.
Yeah.
Yeah.
Sorry, okay, I think that. So if, taking my last point, if she's got a large dam,
Mhm.
say 100,000, because that's another one that someone's talked about. That doesn't, it requires you to go. It doesn't necessarily say it's a medium or high PIC.
No. No.
It can be a
it's
very, very
about
large,
risk.
it's about the risk after, you need to have it assessed.
Yes.
The size takes you to the need to have it assessed, but it still can be.
Yeah.
Just been really clear in our heads
Yes.
about that. Okay, thank you. Okay, Port Blakely we're dealing with later.
Mhm.
So do you have any other questions on that? You're all good? You've got
Yeah.
this sort of in your head?
Yeah.
I just want to make sure we've covered off the points. Chair Plenary talks about the contractors being certified. That is more or less what happens with the MP with the audit, isn't it?
Yeah.
And we can't design or standardise designs.
Also didn't recommend any actual changes to the policy.
Hmm?
There wasn't actually any recommended
there
changes
wasn't.
to the policy either.
No. The next one, we didn't have a name on, so I'm very confused.
The next one, yes, so I think this is go back to the summary. Jeremy Anderson, so
Oh,
he's
MIC.
yeah, so he submitted for himself and then also for MIC.
Yeah.
But it's very similar, if not the same wording.
And then Glen Eyre as well, so three.
Yes, yeah, the three are the same content.
So, and which one did you say?
Glen,
Dawn
Oh,
Sensors.
Linear. Yeah, Dawn Sensor, sorry.
Yeah.
Sorry, yeah. I'm going through the actual list, not through your notes, apologies.
Yeah, no, I'm on the same as you.
The actual submissions, and they don't come up, you've redacted a whole lot of stuff, which makes it harder.
Oh,
Right.
yes.
So the policy amendments is the size, which we can deal with as we did earlier.
Yeah.
We can't deal with the assessment model, that's beyond our. And we can't do it with irrigation consents. Again, it's outside of our
Yeah.
scope or our ability, not our scope, yeah. Certainly we could say that there are some things that would make more sense to align, but. So they talk about low risk, but then they talk about annual operations and maintenance report. As required to be kept as
As
part
an
of.
alternative,
Yeah,
yeah.
but that's where the auditor would deal with that as
Yeah.
potentially that process. And if it is low risk, then it's only every 5 years. And they'll just have to accumulate those as part of that report that they then provide. That 2-pager at the back that they,
The DSAP, is that?
no, the other bit, the PIC.
The PIC.
Yeah. You're that's the sort of information that you would supply.
I would imagine so,
Yeah.
yes.
And unfortunately, the Building Act doesn't sit well with freshwater farm plans, I think.
No, it does not.
As much as it may seem efficient.
and so the submissions that were not happy about. Or a bit wary about in due time or whatever.
Timely manner.
Timely manner, yeah. Yeah.
There is a framework for that timing as you've sort of been through just before for a lot of the actual.
Yeah, so
Stuff,
under the
but then,
regulation
yeah.
requirements, there's set timeframes,
Right,
but in
set
terms of
timeframes.
notifying for the policy, it's very hard to specify,
Of course, yeah. of
yes,
course.
a set timing of when,
Gonna depend, yeah.
depending on a number of factors, yes.
And so I definitely get being a bit wary about, well, am I gonna be too late if it's, but I would just think it's just whatever a reasonable time would be and as long as we weren't being unreasonable about that, then there wouldn't be an issue there.
Yeah. I guess there would be a risk the other way if we set a timeframe that was
Exactly.
unachievable.
Yeah,
Because it would
in order
depend
to
on-
make it reasonable, it would have to be sort of too far out for it
Yeah.
to be.
Which if it's a you know, there's a lot of different risks with these dams. Some, you know, it may be a flood prone dam, but the risk is quite low at the moment versus something that's I can't say
Imminent.
yes, to fail. It would be very hard to set a timeframe around that.
And the exact notifications doesn't feel too onerous of a task. That's just
No,
a notification.
no,
Obviously,
notification.
the paperwork you want to give enough time to do, but
Yeah.
notifying should just happen.
Yeah,
as soon as
hopefully
you
it's
find out. Yeah,
Phone call and an email.
Yeah, exactly.
Yes.
I'm comfortable with that.
Yeah, the imminence of one, because it's the engineer that has to notify you,
Yes.
and it's in writing. And it's 5 days, up to 5 days. Am I looking at the wrong part of that?
Mm,
Which I did think of, that there may be a slightly more urgency to some of that. This is the problem, because I think we may be talking cross purposes. Hold on.
Yes, so in the principles, principle 2, a suitably qualified and experienced engineer engaged by the owner to provide a certificate for the purposes, it lists a number of purposes under the Building Act, must notify the council and the owner of the dam in writing within 5 working days if he or she or they believe that the dam is dangerous.
Right, and then it's on the owner to notify.
So council would then be notified, and I'm just going to check where the timely manner.
Yeah, where is it? This is where I've done my head in.
So that's the working with dam owners, section 4.2. The regulations require owners of all classifiable dams to know whether their dam is dangerous, earthquake prone or flood prone, and that they will take the necessary steps in a timely manner to comply with the Act and the regulations.
So if an engineer assesses it to be dangerous, then there's that 5-day timeframe.
Yes, so they'll notify us within 5 days, hopefully sooner. And then it'll be the working with dam owners, the steps required will be undertaken in a timely manner.
Yeah.
So that would be an agreed upon timeframe, I would imagine.
So I'm absolutely lost because there's so many numbers here.
Yeah, so
it doesn't. Waikato set this out slightly better. It's easier to read.
yes, so it's 4.2, section 4.2, working with dam owners.
No, I can't.
On page 5.
I'm looking at the statement. Sorry, I'm looking at the wrong one. Draft policy.
Updated draft policy.
So you're on the draft policy.
Yes.
4.2. Sorry. Working with dam owners. So the regulation of okay. So the timely manner refers to whether if it's medium, they've got up to a year. And then all the other subsequent notifications they have to do after that.
For the regulations,
yeah.
Yeah, but in terms of the timely manner for if there is a dangerous earthquake prone or flood prone dam, the steps taken to comply with the Act and regulations to ensure it's safe need to be done in a timely manner. So that would all depend on the individual situation.
Well, interestingly, you used the word safe there, but it's not in that sentence. It's comply with the Act. And that comes down to that question I had earlier about the purpose. The purpose isn't to meet the Act.
Yes.
The purpose is to be safe.
Yes.
And people just be safe. And it's not really one that we've got a submission on. I don't think it changes the meaning, but it took my head in reading it. The previous, the purpose of the Act is to make people safe.
But the purpose of the policy or the Act?
The policy.
Right, yeah. I do agree that that's what it should be, I guess.
Well, the policy used to say, talk about people safety.
Yeah, I've read that and I think it would make sense to incorporate. Yeah,
And then that makes all of the other stuff much more sensible going
Yes.
through. We're not here to comply with the Act.
Yeah.
I think that would be, we're here to make people safe.
Yeah.
And I think that's where some of that alignment's possibly missing. And people have focused on, because of the way it's written, on compliance with the Act and the regulations
Yes.
rather than the
Yes,
end goal.
yes.
But I guess, yeah, on a technical level, like it is there to comply with the act. So maybe if it's just explained like that the policy is there to comply with the act,
Yes,
to
which-
provide that safety or something rather than,
The second part of that
One or the
purpose, I
other.
think, states that in the original
Yeah.
policy. Yeah,
And the existing policy,
yes, existing, sorry.
existing, yeah,
Yeah, the 2011 version.
yeah, which I quite like the wording there. I think it actually, yeah,
Yes, minimise the safety risk of dams in Otago and comply with the statutory provisions.
Mm.
Of the, and we would have to add in there the dam safety regulations as
Yeah.
well.
I just think it makes the whole thing look, yeah.
Yeah.
Okay. Okay, sorry, next submission, have you got that list? If you, mine's jumped away.
which one?
We've done Grenier, John,
Up to
Sure.
Bruce Smith, Eden League
Yeah.
Partnership.
yeah, and their point was,
It was a query around a specific dam.
What regulations apply to two areas?
sorry, wait, I'll go back to that. I'm sorry, I'm not working on something, I'm working on the other one.
Asking what regulations apply to the two barriers crossing Eden Creek.
Oh, this was sorry, this is a guy, this is
Rail.
culverts, they don't apply at all because they're culverts.
Yes,
And they're
so
not dams.
I passed this on to compliance to get in touch with Bruce, and I understand that they've done so to explain the regulations to him.
Okay, and that, yeah, the effect may be the same as having a dam if something breaks, but it's actually, the irony is it doesn't relate to flood banks, which equally put you in the same position. But they don't apply. Yeah, and then the next one, I think, is just the Heritage New Zealand, which you've dealt with and
Yes,
accepted their submission.
yes.
Just from my own mind, and Fool's Day may or may not be an example, and I should perhaps. If you've got a heritage dam, how much more difficult is it being compliant?
I do not know, I guess it would depend on the state of the dam.
Yeah.
Yeah, so it would be up to an engineer to demonstrate that, I'm not too sure, sorry.
Yeah, it depends on the urgency, and I just felt reading it that urgency didn't seem to be a matter that was.
Hmm.
If your risk is substantial, and we've already had that example, maybe it's a question this afternoon for,
Port Blakely.
yeah, Port Blakely, because their situation, it is a heritage dam, I think,
I believe so, yes.
and yet the council went in or asked, and they, I think, assisted immediately
Yes.
with dewatering, but if it had been another situation, given the risk, I imagine, yeah, it wasn't clear in my mind, and I think it should be clear that should there be an urgency, that there should be something that overrides. I'd hate to think heritage would trump a risk, or maybe I've got something wrong there. Tammy, you want to?
My understanding is that heritage, in that case, there weren't any impacts on the heritage values of the dam, but that there is no emergency provisions under for archaeological approvals and those sorts of things. They don't have the equivalent of emergency provisions.
So the effect is, just check that I've.
That if they were to undertake emergency works without getting the right approvals from Heritage New Zealand, that they may be liable for enforcement action in relation to those activities. It's just the legislation doesn't provide for emergency provisions.
And we can't do that by policy,
No.
which makes the risk of owning a dam even worse.
If you're the heritage dam.
Well, no, it makes the risk for the people below, actually. I mean, the risk, it makes it very difficult for people to manage the risk if you're reliant on getting Heritage New Zealand approval.
Yeah.
I mean, that is something we could consider making a comment to. Yeah. Well, I think, can someone please remind me to ask Port Blakely about that this afternoon, because inherently, if you've got that risk, if it was a building, the council, so if it comes out of the Building Act, if you've got a building, you can demolish it under emergency to protect people.
Yeah, I can look into that more as well.
I just, no, don't look into it. I think it's just a
Just a
question.
question to ask.
It's a question to ask them,
Yeah.
because I mentioned it does,
Mm.
yeah. Depending on where you are, in Dunedin, we're very lucky to have a very active Heritage New Zealand, but if you were out on the West Coast or out in a small area, or even, where those access to that advice in parts of Otago wouldn't be as easy to get, that could, okay. That is, I think, all of the submissions until we get to Port Blakely in here. Are there any other matters? Oh, sorry, Fed Farmers.
Yes.
Fed Farmers. These were costs.
Did they decide concerns of all?
Are they worried about our certificates? How many, do we know how many have been certified in Otago?
No, I don't know that number, sorry.
To a review mechanism, but.
Yes, a review mechanism.
Same.
It isn't provided for. There are reviews in the current policy. If you want a PI, I think in the current policy, if you challenge the assessment, there was a process.
I have to double check that.
Or in some policies, I read.
Sorry, I've got so many tabs open.
Yeah,
with all
that's all.
different things.
I'm actually giving up on looking at them. I've got far too many open.
What did I open?
Maybe it's not in this current one. I think it's in, maybe it was one of the other ones I looked at.
They had concerns about the lack of enough engineers.
Yeah. It's a capacity issue.
And
No, I can't find anything about the.
No, it isn't in this one. And maybe it's in one of the other ones I read.
Yeah. It's not in the current.
they wanted a review mechanism, independent
So-
peer review.
Bay of Plenty has one at the moment. Dispute by owner of classification. No.
Mhm.
But that's under the old policy, which is different.
Or why not seek a second opinion?
Yeah.
If an engineer recommends substantial changes.
But in this case, the assessment comes from themselves. So your option is to go to another.
Yeah.
The onus is all on, the responsibility is on the owner. And if
Yes.
you don't like the first engineer's report,
But I guess the first engineer would be required if they did
Would
think
you
it was, yes, they'd be required to notify us,
yeah,
regardless of whether they then went to someone else.
yeah.
So I guess there's that risk.
So what would happen if they went to another engineer after that, after we'd been notified?
I
and the
guess that would be,
engineer
yeah, it
assessed?
would be taken into consideration.
But we don't have a mechanism clearly stated.
No, we don't.
Disputes resolution. Even being between medium and high becomes a very much a subjective call.
Yeah, but that would be managed under the regulations rather than the policy.
Yeah.
But yes, I imagine so.
And so there's no review mechanism in the legislation.
Not that I'm aware of, but I can.
No, I don't think there is.
No.
But it's about you file another report because you
Yeah,
may have done
yeah,
some
you
work. It'll come up through in your DSAP.
Yeah.
So it would,
So
yeah,
your safety action plan. I mean,
Yeah.
what you would focus on, I would hope, is not challenging the engineer, but saying how do I make it safer and
Yes.
get that better report.
yeah,
Yes.
And so what we have to be clear is that we're motivating people to do spend the money in the right place
Yes.
and they get benefits out of that. So going from high to medium would give it a year. It would give 5 years for their 5 years
That would give them a year more
on
to
their
get the DSAP,
SAP.
but then everything else is still the same.
So no,
They'd have 10 years, they'd get an extra 5 years for the subsequent reviews of that.
yeah, that's what I meant.
Yeah.
So we want to make sure that we're driving the best behaviour.
Yes.
And that's fine. Policies are policies. It is the wording that I found really difficult reading this, and I don't think it is redoing the legislation, which isn't necessarily helpful with the policy. But I appreciate that it's template, and I don't want to necessarily get in the way of that. I do think that the guidance, simplification of the guidance and process, and that table may be helpful, but and linking to the building
Yeah.
act guidance for people.
Yeah.
That comes as a comms piece afterwards because it's really overwhelming reading it.
Another option could be to have a separate document with that clearly outline the regulations
Yeah.
separate to the policy, but yes.
Absolutely, and that's what I'm meaning because
Yeah.
I don't think you want to. The policy template is possibly when we should have dealt with that. Yeah, it's also the formatting, which the same wording like that looks easier to read than
It
ours.
does, I agree with that, yes.
Yeah.
Yeah.
Without them.
Okay.
Yeah. Okay, we're just adjourning. Might as well adjourn until 12:30.
Yeah.
Thank you.
So
Welcome back from the adjournment of the hearings panel on the dangerous flood prone and earthquake prone dams hearing. Welcome, Sherilyn. How's that, Sherilyn? Is that
Correct, yes.
Thank you very much. You're here submitting on behalf of Port Blakely Limited. We've read your submission and we're familiar with it, but we'll very lucky to have you on board. We actually glean a lot from people being heard, and we also have the chance of asking you questions, which also helps us in this hearing process. So, feel welcome to just advise us of your concerns in an oral presentation. I gather you didn't put this together, but you're speaking to it.
Correct. So I've worked alongside our legal support team in drafting our submission, and I've got a few things I just want to run through in relation to that. Firstly, I'll just do a bit of an introduction. So thanks everybody. My name's Sherilyn Byron. I'm the Health, Safety and Environmental Manager for Port Blakely. I've been with the company just over a year, so relatively short time. Prior to that, I've worked in local government for a number of years as a senior consents planner, so I'm familiar with policy reviews and all things resource consenting. So our request, so in summary, Port Blakely's submission on the Otago Regional Council's draft dangerous dams policy relates to 3 key points I'm going to reiterate. Timely access to information about dangerous dams, registration of all dams on any LIM reports, better engagement with the public during emergency situations. Then I'll just run through a little bit of context to each of those submission points and then the specific relief requested. So in terms of access to information, what we're seeking is there should be an obligation on the Otago Regional Council to provide on request any technical reports they may have which provide details about the state of a dangerous, earthquake-prone or flood-prone dam. Why? The provision of technical reports help persons potentially affected by either dangerous, earthquake-prone or flood-prone dams to plan for and eliminate risk. via mitigation measures. Our specific relief in terms of the policy, we ask that section 3, the principles, paragraph 3 is amended to include an obligation on ORC to provide at the request any technical reports that you may have, which provides details about the state of a dangerous, earthquake-prone or flood-prone dam. In terms of registration of all dams on the LIM report, so just as a bit of context, section 4.1, so information on dam status, states that the ORC will record the heritage listing of all dangerous, earthquake-prone and flood-prone dams and supply this information to the territorial authorities. Those authorities will then include that information on the Land Information Memorandum or LIM reports. So we agree that the above policy is sound, however, we don't agree that it goes far enough. The policy should be revised to ensure that the safety of dams are managed in a more proactive way and to ensure future buyers of land are well informed about the presence of a dam on a property, any risks and any heritage values associated with that dam. Contextually, so Port Blakely was somewhat blindsided by the presence, state and the relevance of Phoenix Dam when it purchased a block of land the dam is located on near Lawrence. The LIM report for the land contained indirect references to Phoenix Dam, but nothing specifically referred to the poor state of the dam, its heritage values, or its importance as part of the Lawrence community's potable water supply. Port Blakely became aware of these things when the dam was already in a very poor state, and not long after that, the dam had been reclassified to a high PIC dam. In terms of the relief sought, section 4, subsection 4.1 should be amended, requiring the regional council to supply information about all dams on their register to the territorial authority, and for the territorial authority to include that information in any LIM reports. Final point, so engagement with the public around and or during emergencies. So Port Blakely has recently been involved in and continues to be involved in the emergency dewatering of the Phoenix Dam reservoir. We consider that more could have been done by the Regional Council and Clutha District Council to lead the discussion with the public about an unfolding emergency involving a dam. Why? We, having regularly updated information in the media about emergencies and, for example, a 24-hour contact number for concerned citizens would have helped people in terms of safety and for information purposes around emergencies. This would have helped to maintain trust with public authorities. In terms of the relief sought, so amending section 4, subsection 3 of the proposed policy, requiring that the regional council update the information, update the public about emergency situations concerning any known dangerous earthquake-prone or flood-prone dam, and to provide a 24-hour number for members of the public to call. And that is it, unless you've got any questions. Thanks for the opportunity to be heard in support of our submission.
Thank you very much, Sherilyn. I'm just, sorry, I didn't introduce myself. I'm Councillor Kate Wilson and Councillor Elliot Weir is beside me. And we've got, I think you've been in touch with Caitlin, but we've also got Rebecca Jackson, the report writer here as well, which I'm very remiss not to introduce them earlier, but Councillor Weir, have you got Elliot?
Yeah, I just wanted to clarify on your point of information sharing. Was there any relevant information ahead of the purchase of the block of land that you thought should have been publicly available that was not publicly available in doing due diligence ahead of the purchase?
So we received general information via maps from the district council, but there wasn't anything specific around the dam structure itself and I suppose its integral importance to the Lawrence water supply.
Right. I'm just wondering if, like, when you perhaps looked at what consents were in place for the block of land ahead of purchasing it or anything like that, was there information that you thought should have been in there that wasn't around the dams?
So I suppose it's mostly about the dam's presence. So the consents that relate to Phoenix Dam in particular are around diversion and take. So and in relation to water courses in different catchments. So they're related to, but not directly related to the dam, if that makes sense.
Thanks.
Thanks, Sharon. I just got I think it goes before your time. When did Port Blakely buy this land?
So it was purchased in 2007, I think, from memory. 2017, sorry.
Sorry, 2017. Was that from Clutha?
No, the land was purchased from it was forestry from Fulton Hogan, I think, from memory. I don't have the specifics. It's a fairly recent purchase.
Yeah, and so Phoenix Dam is the dam just for the Lawrence water, or does it do other things as well?
It's just for the Lawrence water supply.
And
Historically, it was used for gold mines sluicing purposes. So it's, you know, over 100 years old.
Yeah. Given the proposed policy, without the suggested changes, nothing would have alerted you more to that. Is what you're saying, I think.
Yes, yeah.
Okay. And does all of currently Lawrence's water system, so when you dewater it, how are they coping for water?
So logistically, there's a pump operating that's going over the dam face because the spillway is now redundant given the reservoir's reduced. So it's with the pumps operating that the water is still going, you know, over the dam and down the catchment, and then that water is diverted by the council as per the consent to the water treatment plant.
Okay, so it's a reservoir that feeds into a creek, but it's not the actual take point for the Lawrence water scheme.
Correct.
Okay, and it hasn't ever been, or it has been in the past?
It has been for 100+ years.
Yeah. Okay. Okay. So they can operate. They don't need the dam. So you bought the land for forestry. Where you're sitting now, what are your future options with that dam?
So I suppose there's remediation or removal.
Okay, that's slightly red herring, but I'm just interested to understand it. So had you done, if the suggestions you've made were put in place, you would have been notified under the TA under a LIM report about its status?
Correct, yeah.
Yeah. Can I just understand better the response time, or actually it may be a question for Rebecca. You made a suggestion in your report about that, and you've been speaking to CDM.
Yes.
Could you just advise us how that would translate?
In terms of what, sorry?
Sorry, what did CDM say about
Notifying.
Yeah.
So they have a 24-hour number, but that's for stakeholders key stakeholders and councils.
Mhm.
And they advise for any other emergency situations to contact the emergency services.
Okay, yeah.
Yeah, that it wouldn't be feasible for them to maintain that.
Okay. Yeah. So and I suppose what you're outlining here is that the onus on a business like yours has been substantial doing that notification and that relaying information.
Yeah, from a communications perspective, yeah. Slightly outside our core business.
Can I be cheeky enough to mine your information as a thought piece as a qualified planner? Is how this would translate if you were a dam owner. Everything was fine with your dam, you found it maybe by surprise, but you got a dam, and someone got resource consent down below for subdivision, and how that translates to something that was a low potentially becoming a high or a medium because of the process here.
Oh,
Would you,
good question.
as a planner, would you anticipate you would be notified of that process? Because the inherent change in the status for you would be quite substantial.
You would hope as the planner undertaking their effects assessment would then consider adjoining or upstream catchment owners to be affected by any potential subdivision depending on the PIC rating of the dam, and then therefore should be included in the planning process as an affected party.
But they'll only know that if the TAs have been notified. And that's where I'm one a scope of one-way direction. The actual benefits would be potentially if TAs had it logged, then the person doing subdivision consent would also be understanding that.
Yes, correct. Yep.
Yeah, and it's interesting to think at what level a subdivision would be have an effect on the status. I'm not quite sure that I've got that in my head right. Is it one house or is it 20 houses that would?
Yeah, I just thinking out loud, I suppose it would depend on the rule framework, and if there was then the ability to further subdivide, then you might say at one, but there's the provision for further subdivision in the future, then that might be the trigger.
Yeah, and just given our role as in at least in urban areas and future development strategies, I'm just wondering whether we do have a function to consider that the TA notified. Yeah. So when you going back to your first point, is that technical reports?
Mm-hmm.
Are you saying that the ORC had technical reports that you weren't aware of and they couldn't give you, or
there were technical reports, but they weren't? Maybe the TA didn't share them, or the TA didn't have a copy of those technical reports and therefore couldn't be included in any LIM. So it's sort of like agencies' information silos.
And what you're suggesting is that it's whether it's a policy statement or whether it's an obligation anyway under the Act as the authority dealing with these things, that we should be making sure that that knowledge is
shared
and shared. Okay, that's an interesting question. While you give one reason to understand it, I'm interested in the subdivision or that land development change that may happen and why it should also be known by TAs. Yeah, just getting. Yeah. Are there any other reasons why TAs would want to have that?
I suppose as it may relate to any of their other functions.
Mm-hmm. Have you looked at getting certified or what that process will require of you?
In terms of Phoenix?
Yeah.
Yes.
Can I understand that stepping process? So I am again mining you for information because I've sat down and tried to work out where the engineers list is, and I found that less than straightforward. And I think that may be something that's ENVI may be taking over. But I couldn't find a list for, say, Otago engineers.
So
It's not something we can change in the policy, but we can make recommendations. And we're just making sure that we're being as helpful and getting as much out of this process as possible.
I suppose as long as any reference to other third-party information is kept up to date, so you can run the risk of some things be out of date and are no longer relevant. We've been working with a specialist engineer team, so I suppose we've got direct dialogue with those personnel.
Mhm.
And it's probably given the work around the Phoenix Dam, that's I suppose what's sparked our attention to all things dam related, the regulation changes, policy updates, etc. So without having access to those specialist engineers, it may have just meant a little more digging for points of contact or where to go to glean that information.
But you found it quite easy to find the right people.
Yeah.
Is this the only dam that you've got on your property? Properties?
We're still in scoping work, so assessing what infrastructure we have throughout the estate in Otago, and then of course wider. So there could be more. I don't have an exact number at the moment.
Okay, thank you. Rebecca, did you have any questions?
No questions from me at this stage.
Okay, you're all good. Thank you very much. Sorry to mine your intelligence, but that's always good and
That's
useful.
okay.
Thanks. Thank you very much for being here and being available to us. It actually brings the whole topic alive, and it makes it a lot easier in the process. And we are trying to make something that's workable and better for Otago people. So really appreciate your time.
Sorry,
Right.
Oh.
you were going to ask about heritage values.
Sorry, thank you. I said earlier, can they please remind me to ask you this question? Thank you for being on the ball. It's interesting. I think you've got heritage values in your
Phoenix.
in the Phoenix. There's two aspects to this. In the policy, it doesn't have any urgency, so it puts heritage over urgency. And so, just understanding how that translates to the your management of the situation when it arose, because it looks like you have to get Heritage New Zealand's approval before you can even dewater potentially.
Yeah, correct. Yep. So heritage, the heritage values took precedence. It's only through the Heritage Act if there's been a declared state of emergency from government. So it's sort of that next step up. And this particular set of facts didn't meet that criterion.
Thankfully, it's good that it didn't, but that could make you very nervous. And and an liability situation with insurance, I presume.
Yes, both. So, there were a few sleepless nights leading up to the pumps starting the dewatering.
So how long did it take to get Heritage New Zealand and resolve that issue?
So to the timeframes, and then we're working through the authority for any future works currently. So that's still being processed.
So but you got notice that there was an issue. I presume it was ORC notified you, and you had to then contact Heritage New Zealand first, almost, or your engineers did.
So we did. It's a combination of parties, that lots of moving pieces.
Yeah.
Given that there was no works to the dam structure itself, the heritage values don't sit with the amenity of the place.
Mm-hmm.
So the dewatering component didn't require the authority.
But there may be cases that would have been problematic.
Possibly, yes.
And again, I don't know if it's within the scope of this actual policy, but it is that where your priority is safety, it seems odd. Sorry, our principles are safety first, that heritage gazumps everything. And I'm just trying to think in my head whether there's a recommendation especially given that this is something that we're looking at being a standard template throughout New Zealand.
So yeah, I've found it somewhat surprising, given the degree of urgency that we were needing to work to with the kicking off the dewatering with Phoenix.
How quickly, sorry, and what was the timeframe? You got into dewatering virtually immediately, didn't you?
Yeah, so the engineers were able to put together a proposal within about a week. So, from the point of change to the point of action on the ground would have been around 7 days, and that dewatering process continues. It's ongoing at the moment, given the volume of water and the need for Lawrence potable water supply.
Thank you. No other questions? Yeah, we're all good. Thank you very, very much, Sherilyn. We're going to be deliberating shortly, and we'll try and get this done relatively quickly. But in order to be at council, in order to be signed off before and active on the 13th of May. But really appreciate your input, and if we can't deal with it and we think they are worthwhile submissions, it's certainly opened our mind to it. Thanks. We may be making some recommendations either to council or to be passed on to government. I think there's some reassessment happening anyway. Thank you very, very much.
Thank you. Appreciate it all.
Thank you. Bye.
Bye.
Now, this is the time where we would normally give you 5 minutes if you needed to, but you probably don't, to think about if you've changed any of your recommendations or if you'd like to consider any of the suggestions that we've talked about.
Yeah, I think the suggestion around the purpose would be useful. Also the removal of the leaving classifiable dams, but the actual size requirements, it makes sense. So we don't have to go through this process again.
So just link to the existing
Just
legislation.
So the way Waikato's kind of done it looks like it would work fine. I guess in terms of the last comments there, if you were inclined to make any changes, would just be important to note that all that information would be publicly available in terms of Lagoima and the Dam Safety Register. So I don't think any changes are needed there.
So the dam register stays with us.
But it's publicly available. I understand it won't be on the website.
But if it, I understand it potentially for their situation, but it wouldn't necessarily open the eyes to anyone doing subdivisions or anything like that.
No.
And that could change the risks quite dramatically. In fact, it could change the assessment. I mean, if there was a dam above a property, it may well change the recommendation of that.
So speaking with my planner hat on, I don't process subdivision consents but I would assume that's something district councils would need to consider and look at like
but they wouldn't be necessarily on notice of it.
No, not necessarily, but
got access to the information.
yes, the information would be available for them to find or for the applicant to find if it was requested.
There was just checking one other thing she talked about. So you've addressed her other issues already. Is there anything in here that limits us if the time frames change that we'd have to redo a policy?
In terms of the date the regulations commence?
I think the regulations probably will commence at that date.
Yeah.
But the other time frames, it just refers to the act.
No, that wouldn't have any impact on the policy.
Yeah. I'm just trying to future-proof it.
Yeah, good idea.
Sorry, your view on the heritage values trumping safety.
Yeah, so I don't know a lot about that at all. but I guess like Sherilyn mentioned, if it's a state of emergency, if it's declared as a state of emergency, at that point, it is
But-
trumped.
But it has to be by government, not
Yes.
by, so a localised event which may affect 5 or 6 houses won't be a national event. Emergency.
But you can have locals.
Yeah,
but
so
she said it
But
had
then
to be
you can't-
government.
Yeah.
Yeah, I might just check that, whether it's,
Yeah, I just
Yeah.
wouldn't mind, I know it's
Yeah.
a technical issue, but that
Yeah.
could have easily been the case here,
yeah,
if it needed to be, yeah. Otherwise you're happy.
Yeah, my only other thing on this living template is just my name's got an extra T in. But
Okay,
other than that,
I would make sure that that's. And you-
no, it's all good.
are you planning to issue a minute to deal with this, and I can respond
Uh,
today, or how would you like that dealt with?
I don't know, it is a technical one, but it does seem, it's inconsistent with the principles.
The hierarchy, yeah.
Yeah, the hierarchy principles are, yeah.
Yeah. Yeah, I just think I might need to seek some advice around it, so.
I just want to understand the process because I
Yeah.
would be deadly scared
Yeah,
that we would defer something that. I mean, the problem is that a lot of these are really old dams. If I didn't think it was relevant,
Yeah.
and the ones most at risk are going to be the old dams.
Which bit in the policy, what's the heritage above, sorry?
The heritage policy requires you to get consent, just by the very nature of the wording. So if you go
Oh,
to the
so
last
that's
section.
heritage policy rather than anything in this.
So the last section, I need to go back to the. Maybe I'm reading it wrong. Happy for you to say
is
that's
it in
wrong.
terms of the advice note that's being added?
Application to heritage dams. For the purpose of this policy, a heritage dam means this.
Mhm.
The council recognises the need to retain heritage values of the dam itself, but also the need to produce, okay. When considering heritage dams under this policy, the council will be taking the need to facilitate, oh, maybe just covered here. Maybe I was looking at the other bit.
Yeah, advice will be sought from
We do
heritage and
heritage
zoning stuff,
dams.
but when considering any recommendations, the council will have regard to the priorities set out, so that's
Okay, it is. Where was I
that's safety
reading?
first.
Okay, yeah, it is. Sorry, I was reading something else before.
Mm.
Advice note.
Although
the advice note, yeah, under the 2014 Act, the permission of heritage NZ must be sought prior to the modification.
yeah, that's the advice note.
Yeah, whether the site is unreported or has been previously reported. Right, so those are
I guess
somewhat conflicting.
technically, from a planning point of view, it says sought not obtained.
Yeah, right. Okay.
I don't know whether that's intentional or not.
Permission must be sought.
Yeah.
Right, so you've just got to go and ask them, and then you can go and do it
Yeah,
whether or not you
yeah.
get back.
I'm not sure if that's how it's meant to be interpreted,
Yeah.
but that's how I would interpret it.
Oh, well, I hope you're not waiting till 9 o'clock in the morning when the office opens. It's an emergency.
Yeah. Interesting.
Send an email and do it.
Because that's effectively informing rather than
Mm.
seeking permission.
Mm.
But obviously the actual act says permission must be sought, so that's
So,
what you've got to say.
Yeah, the referable dams, you're going to delete that as well?
Yeah, I might just double check that because I note it, I understand it means large dams, but in the footnote, it outlined that it's not actually specified yet. So if it comes in and is something else,
Mm.
then I guess we don't want to have to be in this situation again. So I think it's been left there intentionally.
But like they would by their very nature already be classifiable dams. And we haven't got any rules around them.
But if the classifiable definition changes,
Okay.
because I think the old classifiable definition was 8 metre, it was quite a bit larger than
Okay.
the large
So
dams.
you'd see a large dam being smaller than potentially a classifiable dam.
If the definition of classifiable was to change.
Okay.
Yeah.
Okay. And you want to keep that policy commencing on that date, not refer to this section. Yeah. Yeah, okay. You're happy with all those other matters?
Yeah.
That's the report.
Everything else.
Yeah. Okay, I might, yeah, in the writing, I just like, but yeah, I'm not gonna do a minute. I'm happy with that. I'll just note that that's advice.
Yeah.
Okay. I think on that basis, we can close the deliberations. I shall get a report out hopefully within a week.
Wonderful. Yeah, if anything else crops up, just let me know.
What's the new trial, please?
So
Short and sweet.